Hello, good afternoon. Welcome to our Flexing Your Workforce and Reducing Your Employment Costs post-furlough. I'm Charlotte Geeson, Head of Employment Law and Business Immigration at Haworths. And it's nice to not see you, but to welcome you to this session. Just before I start, I'd like to do a quick sound check, if that's okay. I'd be grateful if a couple of you could just open up the Q&A box and type yes, if you can hear me, please. Perfect, excellent. Thanks for that. I'm going to assume if any of you have any sound or connection issues, that on the basis of these responses, the issues at your end as opposed to mine. If the connection drops or if you are having any issues, then my colleague Louise is diligently sat in the background, and if you just type the issue into the Q&A box, she'll do her best to see you right. So as I say, welcome, and welcome back to my living room for those of you who've been on a session with me in the last couple of weeks. 64 days I have been locked in here now, but still smiling, and hope that you are all well too, and that you had a nice bank holiday weekend. Big week this week, in theory, when it comes to all things furlough, insofar as we are expecting the Chancellor, Rishi Sunak, to confirm the details as to what the furlough scheme is going to look like post 31st of July. We're awaiting all the official details. However, you may have seen over the weekend that it has been reported in a couple of the newspapers that it is likely employers who want to continue using the furlough scheme post July are going to have to make a contribution to their employees' wages. The percentage figures which have been bandied around are between 20 and 30%, and there's also been some mention of an increased contribution towards national insurance contributions as well. So we'll wait and see what Mr. Sunak has to say on that, but as soon as we get anything through, we'll let you know. Similarly, Boris Johnson doing his big 3-weekly announcement on Thursday, so we'll see what that brings too. I don't expect there'll be too many sort of employment related pieces of information coming out of that, but we'll see. He's always one to surprise us, I guess, is Mr. Johnson. So in terms of today's session, given that we know the furlough scheme is changing in a couple of weeks and being withdrawn in a couple of months, the end of October, gonna sort of like turn our attention a little bit to how you can sort of manage your workforce once that government support has been withdrawn. And a number of you might be sort of planning for the future, and indeed a number of you might be sort of looking at your current situation and thinking, actually, even though the furlough scheme is in place, we do need to make some changes to our workforce to help us to adapt to, you know, the sort of new normal, if you like, when it comes to business operations. I'm going to be taking live Q&As in this session like I have done previously, and I'll do my best to answer as many as I can. The questions that have been submitted in advance, where it's been possible, I've tried to build those into the presentation, so listen out. Those questions that I can't get round to in the next sort of 30-40 minutes, don't worry, I'll be prepping a sort of Q&A sheet in the next sort of 24-48 hours, which will be sent to you all following this webinar, and which will address all of the points that have been made. Just before I get into the meat of this session, an administrative point, GDPR, this session is being recorded. So if you're unhappy about that, then unfortunately, I hope you don't, then you'll need to log off. Now. Hopefully none of you logged off then. I think without a doubt, The government's job retention scheme has been a complete lifeline for businesses, large and small, up and down the country and across all industries. And, without attempting to bring, politics into this, I think that the scheme is commendable in many ways. It isn't perfect, but what is? But it is no doubt allowed many businesses to sort of weather the first part of this COVID storm. We know that the scheme isn't going to last forever, however, and we can expect to see changes, quite radical ones really, within the next few weeks. But essentially, like I said, sort of in the opening, I think businesses now need to be sort of prudent in terms of future planning, to look at how they're going to weather the next phase of the storm that's sort of inevitably coming, probably. When it comes to sort of flexing workforces and reducing employment costs, there isn't going to be a one-size-fits-all approach. And this webinar is going to sort of seek to provide you with some general information about the main options that all businesses have. Each business will obviously be different in terms of its needs, its desires, its existing contractual obligations, which will be relevant in respect of some of the options available to you. And also in a commercial sense, your sort of willingness to accept a degree of legal risk. Some of the options are safer, if you like, in terms of legal risk than others. So I think what I would just say at this juncture is, whatever it is you need to achieve, there will be a way. Working out exactly what steps you need to take to get you to where you want to be is, potentially going to be a time-consuming and arguably tricky exercise, but you'll get there, and we can support you in as much detail as you need, with anything that you need to do sort of post or as we near the end of furlough. So please feel free to get in touch with us at any time, if you do want to discuss sort of the support that we can offer you in respect of any changes that you need to make to your workforce. When employers turn their attention to reducing staffing costs, I think the immediate thought is that of redundancy. And redundancy, obviously, being one of the 5 potentially fair reasons to dismiss an employee under the Employment Rights Act 1996, has the effect of completely and permanently removing an individual and their associated employment costs from a business. Now, in some cases, that will provide the perfect solution. And it might be that a number of you sort of out there in the ether are thinking that is what you're going to need to do. And if it is something that you're looking at, either now or for the sort of foreseeable future, the good news is that there are no time constraints on redundancy proceedings. Even though we have the furlough scheme in place, in theory, a business can make redundancies at any time. A redundancy situation is essentially a response to a business need, and the law doesn't seek to restrict employers from being able to address any such business needs when it comes to the timing of any action that you might need to take in respect of your employees. That said, when an employer does want to look at making redundancies, one thing it absolutely needs is a genuine need to make redundancies in the first place. Essentially, you need a business case to make these changes to your workforce. Only you can do that as sort of business owners and HR professionals. It's not a legal decision that we can make for you. It's a commercial decision based on your inputs, outputs, staffing costs, overheads, etc., etc. And in some respects, it takes into account your sort of plans for the future in terms of your structure of your workforce and the allocation of your workload. But I think whatever it is your business case turns out to sort of hinge on in the most detail, usually there is an economic driver behind a redundancy situation. Employers want to make redundancies in order to keep finances looking healthy. And there's nothing wrong with that. That is absolutely fine. And where an employer can show that they need to reduce headcount so as to save costs or maintain profitability, then when it comes to a tribunal situation, that employer generally won't experience any difficulties really when seeking to justify their decision to place certain employees' roles at risk of redundancy. I think even though it's usually some kind of financial driver that underpins a redundancy situation, an employer doesn't necessarily need to have a financial reason for making redundancies. And the reason for that is because the statutory definition of redundancy refers to a cessation or reduction of work of a particular kind. So to that end, it might be that your business is financially sound, it's fine. But after considering something like your employee structure or the allocation of workload, because of what has been thrust upon you by the COVID situation, you might identify that actually going forward, there's going to be less of a need or no longer a need for a particular role to be undertaken within your business. Again, due to the statutory definition of redundancy referring to that cessation or reduction of work of a particular kind, in order for an employer to show that it has a genuine need to make redundancies, that employer doesn't need to show that it no longer has a need at all for a particular role to be carried out. It's more than sufficient to say, for example, that for whatever reason, a particular role has diminished. So you might be able to say, okay, we have an operations manager and we still need operations to be carried out. There's still a management function for that. But due to the fact our order book has halved because of the COVID crisis, actually what we now want to do is bring the remaining operational requirements that we have into somebody else's role. That is perfectly fine. That absorption of duty is fine. And that absorption of duty can in itself constitute a genuine redundancy situation. Once you have identified your business case for redundancies, and once you've sort of worked out what it is you're trying to achieve, the next sort of part, or the start really, I suppose, of the redundancy consultation process is the pooling. Now, the pooling is essentially the exercise in which the employer identifies those roles which could be reasonably affected by the overarching need to make redundancies. It's vitally important to convene a proper pool. And in my view, it's actually the pooling side of things which presents the most risk to an employer in a redundancy situation. And there's a number of reasons for that. The first being that generally speaking, there will be a right or a wrong way to pool employees. Because a redundancy situation looks at the whole of the work of a particular kind that's reducing or stopping completely, the employer then has to look at every single employee who does that work. So you must ensure that you properly carry out an assessment of what individuals are doing in practice. Their job descriptions kind of become a little bit irrelevant because it's all about what they're doing day to day and deciding whether actually they are affected by your overarching proposals. Similarly, if you get the pooling wrong, that in itself can be grounds for an unfair dismissal claim. And if you include someone in the pool or exclude somebody in the pool, exclude someone from the pool rather, in error, then that gives an employee scope to start arguing things like discrimination, which is obviously not something that you want sort of crossing your desk at any time during a redundancy situation. So it's like I say, very important to apply proper thought to the pooling exercise. Another sort of point to make on the pooling side of things is that there is a very, very fine line in some cases between a genuine redundancy situation and a change to terms and conditions. Now, on the face of it, you might look at somebody's role and think, actually, we don't need this anymore, or we only need a portion of it. it's redundant. But actually, when you start getting into the weeds of things, it turns out that you don't quite satisfy the necessary sort of threshold requirements for it to deem it as a redundancy situation. And instead, actually, what you're looking at doing is varying that person's role by varying their terms and conditions, maybe reducing their pay down or their hours of work or their contractual duties. And if you get that distinction wrong and include someone in a redundancy pool when actually their role's not redundant, all you're doing is looking at changing their T's and C's, then that can cause problems too. So I think in terms of the pool, the key message is it's very important to get it right. It's not always easy to get it right. And where possible, you should be considering taking advice, particularly if it's not just a straightforward one person is exiting your business, or you're selecting from a very clearly defined pool of employees who all do the same job. In terms of the redundancy consultation process generally, and irrespective of how many people are in the pool, a dismissal by way of redundancy will only be considered to have been effectuated fairly if the employer in question has engaged in a meaningful consultation process with the affected employees. Now, as with 95% of employment law related concepts, there's no definition as to what meaningful consultation means. However, from sort of practice and cases which have been tested in the employment tribunal, we do know that really means having a series of meetings, 3 usually, that are face-to-face, although these days Zoom basis about as good as we may be able to facilitate, and you must have that consultation over around about 2 weeks. This webinar it's not covering collective consultation. That's a 3-hour session probably in itself, but do bear in mind that if you are seeking to put more than 20 employees at risk of redundancy at any one time, then collective consultation rules will apply, and the main sort of consequence of that is that the consultation window must be at least 30 days. You can't shorten it to 3 weeks, 2 weeks, 1 week or anything else. You have to have a 30-day window. So if you are looking at or considering looking at making mass redundancies in your planning stages, make sure you factor in that month-long consultation, because that's going to be very important. Whenever you're consulting with your staff in sort of the normal way, i.e. outside collective consultation, the process will begin with a semi-formal meeting with the affected employees to bring to their attention the fact that their roles are at risk of redundancy. During this initial consultation, the employer should explain to the employees why there is a redundancy situation, so the business case, and why it is their roles which have been placed at risk over anybody else's. It's actually pooling point. You should also, in that meeting, try and give as much information to the employees about your intentions with regards to the ongoing consultation process too, that being the sort of 3-meeting type plan over a 2-week period. During this sort of initial at-risk meeting, at which really you're just confirming the fact that their roles are at risk and the reasons why, you can, as an employer, raise the subject of voluntary redundancy. And I generally advocate this, actually, because you don't actually have anything to lose. If you know you need to make redundancies, then asking for volunteers can be a really nice, neat, quick, non sort of antagonistic way to kind of get to where you want to be. If somebody wants to leave and they're quite happy to, then great. You might as well explore the possibility of them going on a voluntary basis. I say you've got nothing to lose in offering voluntary redundancy because you haven't. Voluntary redundancy is actually an application process, and it sounds a bit weird, but ultimately if the wrong person applies to you for voluntary redundancy, i.e. your most expensive one or your favourite employee, then you can actually knock back that application and just continue with the compulsory redundancy process. If you do decide to go down voluntary redundancy and you do get people successfully applying for it, then the outcome is exactly the same as a compulsory redundancy. They're still dismissed, they're still due notice pay, they're still due redundancy pay, and you still have the same options when it comes to the way in which the notice period runs. Once you've placed your employees at risk of redundancy and sort of dealt with any voluntary redundancy applications that may be forthcoming, the rest of the consultation process will depend on a number of factors, including who's in the pool, the number of people in the pool, and of course your intended outcome. Employers will also, for example, need to implement an objective selection and scoring exercise if you need to choose a number of people to let go from a wider team. Specific advice usually on the form of the consultation should be sought, and if redundancy is something that you need to look at, but you're a little bit nervous about actually handling the process yourself, that is something that we can support you with. At Howarth's, our HR projects team are perfectly placed to sort of come out, well, maybe not come out during COVID. We can come out if you're COVID secure, but either way we can facilitate the consultation meetings for you and have all those awkward conversations on your behalf with your employees, and again, if that's something that you wanted to talk to us about, then by all means feel free to do so. I think when it comes to redundancy, in conclusion, it will be the right solution for a lot of employers in a lot of situations, and it will give the outcome that you need. However, redundancies can be extremely costly, and I think that the sort of odd thing about the situation that we're in is that you want to be making redundancies to save cost, because of what's happening with, you know, COVID and the furlough scheme and the future looking in some respects a little bit bleak. But actually, in order to achieve those costs, you've got to achieve those cost savings, rather, you've got to expend to get there. So it might be that you want to look at some of the other alternatives, which we'll come on to in a second, at least in the interim period, to see if you can stave off that initial cost liability of redundancy dismissals. Redundancy dismissals obviously attract a redundancy payment, but they also attract notice pay. So don't forget the notice pay part of the termination payment. A lot of people do. And also on termination, the employee is entitled to all the usual contractual payments, so accrued holiday, pension benefits, and that sort of thing, which are obviously dictated by the employee's specific contract. There is a bit of a silver lining when it comes to the cost side of redundancies, and that is if you dismiss an employee during the furlough period and serve them with notice while they're on furlough, you can claim 80% of the notice pay back under the job retention scheme. You'd be strongly advised to top up the notice pay to 100%, but obviously, particularly if you're dismissing a long server, if you can get 80% back of 8, 9, 10 weeks notice pay, that's going to help. I said it's a sort of silver lining, because on the opposite side to that is a very big question still over whether or not a redundancy dismissal during furlough will be considered reasonable. It's a question really of timing. Obviously, this hasn't been tested in any tribunal yet. No claims have been brought on this basis, so we won't know for a few months how this sort of tribunal system is going to deal with redundancy dismissals during furlough. But it seems likely that an employer is going to have to work very hard to convince a tribunal that they needed to dismiss an employee on grounds of redundancy in the furlough leave period, when the government's actually covering all of the employee costs. Now, the sort of risk to employers will obviously diminish come the 1st of August when you start having to contribute to your employees' wages. And actually, I would probably suggest that if you're thinking about making use of the notice pay claim point, that you maybe look to waiting to make redundancies until the 1st of August has passed, and you can start arguing that actually the extra burden of the contributions that you have to make is leading you to have to make the redundancies to facilitate those cost savings. I think if you are looking at making redundancies at this point, just check in with us first, and we'll sort of apprise you of all the risks in terms of your timing and otherwise. Like I say, redundancy is going to be a great option, and the right option for a lot of employers over coming weeks and months, I think. But we're working with a moving target, I think. Every day, something else seems to change and something else comes out that businesses need to react to. And on that basis, I can sort of understand why business might want to sort of just hang fire a little bit, see how things pan out, and maybe hang fire on actually making redundancies. And if that is something that you're sort of contemplating, or if you're sort of thinking, actually, if we've just got a couple more weeks, once the furlough scheme ends, or once we decide to withdraw from that, to see if business improves before terminating employment, then it's the layoff scheme again that'll really potentially pay dividends here. Layoff is essentially an alternative to redundancy, and it allows an individual employer to keep employees employed, but without there being an obligation to provide them with work and to provide them with any pay. You can lay employees off post-furlough if that's the way you want to go. And if you have an existing contractual right to lay people off, then there's nothing else that you need to sort of worry about, really. You can just tell your employees that that's happening. If you don't have a contractual right to lay your staff off, then you do need their agreement. But if that's something that you want to look at doing, then again, maybe get in touch with us so we can talk to you about the best way to get that consent. For those of you who have furloughed employees and who used our template letters, check it, because there should be a provision in there which gives you a contractual right to lay off at the end of the furlough period. So even if your standard contract doesn't have it in, the letter will. Layoff, like I say, is when an employer doesn't have to give an employee work for a period of time and they're not entitled to any pay. The sort of sister option, if you like, is short-time working, which is when an employer has work but not all the work. So they might be employed for 5 days, but they only work 3 or 4. And in that circumstance, the employee is obviously paid for the days that they work. In a layoff situation, which is no work, or in a short time working situation, which sees the employee dip below 50% of their normal hours and pay, the employer is obliged to pay a statutory guarantee payment. Now, the statutory guarantee payment is it's peanuts, absolute peanuts. It's £130 in a 3-month period, and that's it. It breaks down as 5 daily payments of £30 each. But that's all you have to pay to your employees in a 3-month period. So it's a very, very cost-effective way of keeping your employees employed whilst you sort of try and work things out. The nasty sting in the tail with layoff and short-time working is that after 4 continuous weeks of layoff, or 6 non-continuous weeks of layoff within a 13-week period, then the employee can actually ask to be made redundant. Now, it's pretty difficult for an employer to reject that request, because what they need to show is that there's a genuine sort of improvement, if you like, in the work situation. Only if you can show that you are going to be getting work very, very soon can you reasonably reject any request for a redundancy payment. So on that basis, layoff isn't necessarily a perfect long-term solution if what you're trying to do is stave off the cost of redundancies. So it might be that, like I say, you use it as a bit of an interim measure, but at the same time, perhaps thinking about some other sort of creative, more practical type approaches, which might help you to sort of make permanent or temporary adjustments to your employees' terms and conditions, which will enable you to hopefully avoid having to bring anybody's employment to an end. The changing terms and conditions approach is perhaps a more pragmatic approach to the lay off and see type course of action. And when it comes to varying employment contracts, it covers everything. So things like reductions in pay, reductions in hours of work, changes to employees' hours of work, implementation of shift systems, removal of contractual benefits like contractual holiday or cars, or reducing pension benefits. Whatever it is, if it's in the contract, in theory, you can vary it. Like redundancies, though, variations to contract require a business case. You need to have an explanation, a driver, an objective driver as to why you need to make that change. But again, if you have a sort of financial driver, for example, we need to give everybody a pay cut because if we don't, we're going to be bankrupt in 3 months type argument, then that's going to be, perfect rationale for making changes to T's and C's. Each business, I suppose, will have again a different business case, but in some respects, I suppose you can almost look at a varying T's and C's exercise as a bit of an employer-led flexible working type procedure. However you view it, whether you view it like that or not, one thing is without a doubt, and that is that changing terms and conditions is a complicated business, and it is probably one of the areas of employment law practice that exposes employers to the most risk. I think more so certainly than with redundancies. But again, with the right support and advice, an employer can successfully make changes to an employee's contract, even where those changes are ostensibly to an employee's detriment. A contract can be varied in a number of ways. By mutual agreement, collective agreement, variations allowed for within the contract itself. In some circumstances, an employer can force changes on an employee. And in the worst case, an employer can even dismiss an employee and offer them re-engagement on new terms. The correct course of action, however, will depend on the changes that you're proposing, the number of employees affected, and of course, your existing contractual rights. Whatever your contractual rights are, though, one thing is very clear. The ideal way of making any changes to an employee's contract is with their consent. This is unequivocal, and it provides a massive reduction in scope for any dispute in the future. And as some of you will know, obtaining consent in some cases is actually a prerequisite to the variation in the first place. So I usually suggest to employers to always set out with the aim of getting consent if you can. If you can't, then it's not always the end of the world, but if you can start off any consultation process with that in mind, then it's only going to be to your benefit, I think. Whether you need to obtain consent or not, if you want to vary an employee's terms and conditions of employment, you're going to have to consult with them. And a bit like a redundancy consultation process, the variation process needs to be a formal consultation. It will obviously need to meet with any terms of any internal consultation policies you have. And again, the collective consultation rules can apply if you're looking at varying T's and C's of 20 people or more. The consultation, again, ideally should be face-to-face if possible. And at the end of the consultation, assuming that you get agreement in principle, what you will want is your employees to sign a letter or an amendment to contract document that confirms their acceptance or their agreement to any changes that you have been discussing. I said a couple of minutes ago that one of the ways in which an employer can vary an employee's contract of employment is through reliance on an existing contractual provision. And that's right. If you have a clear provision in your contract that's reasonable, both in terms of the employment law provisions and also the unfair sort of contract terms provisions that are provided for in commercial and contract law, then there's no reason why, in theory, you can't seek to move forward on that basis. However, what I see on like time and time again, really, is employers who have a really general, vague provision in their contract which says something like, we reserve the right to make any changes to your terms and conditions provided we give you 28 days notice. Now, I don't really understand why those clauses are in contracts, but nevertheless, that it's fine, they exist in some. And the reason I don't really understand why they're there is because they don't mean anything. They're essentially useless when it comes to making meaningful changes to terms and conditions of employment. They don't offer any clarity. There's no level of certainty there. An employee can't really be seen to have genuinely accepted a clause like that when they enter into the contract with you, because it doesn't provide any detail. Does that clause mean that you will, I don't know, exercise your right to remove, 10-minute smoking breaks at some point? Or does it mean that you're going to subject them to a 50% pay cut every 3 months? They don't make sense. And I think the point that I'm trying to make is that if you have those clauses in your contract, they are not going to be sufficient for you to simply be able to vary your employees' terms and conditions of employment to enable you to adapt to the sort of post-COVID world. You are almost certainly going to have to follow a consultation process with your employees of sorts. So please do bear that in mind. That sort of change in terms and conditions, you can start changing terms and conditions of employment during the furlough leave if you want to. You can start consulting with your staff while they're off, and there's no sort of risk like there is with making a redundancy termination of implementing any changes during the furlough period. It's fine. But obviously, again, you might want to sort of see how things pan out before making any sort of definitive decisions on changing terms and conditions. But one thing that you can do if you want to is make temporary changes as opposed to permanent ones. That's absolutely fine. You can make a temporary change and see how it goes. You can either then make that change permanent if it works for you, or you can sort of withdraw it or just keep it under review. The law is pretty flexible when it comes to varying terms and conditions of employment in that sense. If you are wanting to take some sort of immediate action, but you don't really want to sack anyone, you don't want to lay anybody off, and actually you're not really sure about varying T's and C's at this stage, then you can look at using the new job retention scheme provisions on annual leave to your advantage to start managing your workforce and reducing your employment costs. Hopefully you will have all seen the update from a couple of weeks ago, which made clear that employers can now compel their employees to take annual leave during the furlough period. And this has without a doubt made things a lot easier for employers who are taking advantage of the scheme. I think that utilising this sort of right is a no-brainer in some respects, because if you've had employees on furlough since the start, they'll be entering their third or fourth month really of furlough leave, and obviously annual leave accrues whilst people are on furlough, and quite literally every day your financial liability is growing in that sense. And I think if you are looking at needing to sort of plan for the future and manage the annual leave cost, it makes sense to start getting your employees who are on furlough leave onto annual leave. It will also, in theory, help you to sort of future plan when you can return to normal, because you're not going to have staff who've been off since maybe March, then having the ability to be off again for another maybe 2 months when it comes to all their annual leave, which is accrued and all that sort of stuff. Maybe 2 months is quite a lot. If you're super generous with your contractual holiday provision, they might have 2 months, but it's at least going to be 28 days, which is the minimum potentially. If you do want to look at compelling your employees to take annual leave during furlough leave, then all you have to do is give them notice of that intention, and you have to give them twice as much notice as the time that you want them to take as holiday in order to fulfill your obligation. So if you want an employee on furlough leave to take a week's holiday, you have to give them 2 weeks notice. The sort of benefit to this is that you can claim 80% of the employee's holiday pay if they take annual leave during furlough leave. As soon as they come back off furlough leave, obviously you lose that ability completely, and you're on the hook for the whole lot. The rollover provision as well, which was provided in March, is also something that you can use to your advantage. This provision allows employers to roll up to 20 days annual leave across the next 2 years. And this applies to all employees as well. So if any of your employees have been unable to take all of their annual leave this year due to the COVID crisis, you can spread the cost and the liability out until 2022. So again, if you look carefully at your staffing structures and your employees' annual leave entitlement, then in theory you can start looking at almost rotaring annual leave to be taken across departments or by individuals over the next sort of 12, 24 months. It's not something that you have to do, but it's something that you can certainly give consideration to. There is a peril that that you should perhaps be aware of if you are seeking to make use of the rollover provision. And that is, there is a potential hidden cost here if your employee leaves. Obviously, the main reason perhaps why you would want to roll leave over in the first place is to try and reduce employment liabilities, reduce your employment costs. But actually, if you have an employee who has been allowed to roll over 20 days of annual leave into next year, and then let's say they leave halfway through next year, having only taken a week's leave, they are going to have a huge amount of accrued annual leave that you are going to have to pay them for on termination. So again, if you are going to look at putting some kind of maybe rota or plan in place, try and factor that in as well, because you don't want to be in a situation where next year or even the year after, where you're faced with huge termination bills from employees who you either dismiss or who choose to resign. In terms of other ways to sort of flex workforces and save costs, there are a couple of other options. You could introduce your own company funded furlough scheme, or you could look at putting employees on forced sabbaticals where you can change their terms and conditions in exchange for them being off work and still employed. But I think that what employers need to do sort of in the immediate sort of future is listen to what the government has to say. Like I said at the very start, Rishi Sunak's going to be announcing details of the furlough scheme of the future very shortly, and Boris Johnson's obviously going to be making an announcement on Thursday with regards to the next phase of the unlocking. And it might be that through those forthcoming announcements, some more sort of details or options present themselves in terms of flexing workforces. For example, one of the things that's likely to come out soon is an automatic right for employees to work from home. We don't know what else is coming. The government has sort of surprised us really all the way along. So my advice would just be to sort of keep an ear out and keep thinking about ways in which you could use any announcements to your potential advantage. On that note, I am only 13 minutes over the half-an-hour slot, which for me isn't bad. If you know me, you'll know that's not bad. If you're still on the line, thank you very much for sticking with me. Really appreciate it, and I hope that you enjoyed that. Like I've said a couple of times, you know where we are if you need us. Please feel free to drop us a line, pick up the phone anytime. And yes, so it's goodbye from me. I hope to see you soon on a webinar in the future. But for now, I'll just hand you over to Louise to say a formal goodbye. Thank you.
Thank you, Charlotte, and I hope everyone found that really helpful, always insightful, as always. So I just wanted to highlight a few areas really that we can support, and also some events that we've got coming up in the future. Now, I know we do have a mix of clients and non-clients on the line. So we do have some people who are already using our employment law support and have used it heavily over, you know, the past few months in going through some of the things that Charlotte's been speaking about. If there is anybody who's on here that isn't and would like to discuss extra support in terms of documentation or advice, then do get in touch. We've also been pretty busy in terms of the health and safety side, picking up because the government announced that businesses need to be COVID secure and you have to have a COVID-19 risk assessment. We've now set up a service where we can go out to premises to do an audit and report and assist you in building the risk assessment that you need. So the other area that Charlotte mentioned, which might be helpful for some companies because it's never nice to go through, is the redundancy consultation with our HR project team. Where they can actually lead the consultation for you, and like Charlotte said, have those difficult conversations with staff. So if anybody's interested in any of the support, we offer a telephone consultation where I can talk you through your requirements and costs. Just email louise@howlets-uk.com or call 01274 864 999, and we can arrange something. And then our next event, which will be hosted by Charlotte again, so that's going to be how to deal with an increase in flexible and home working requests, held on the 22nd of June, which is a Monday. We will be doing a 10 a.m. and a 2:30 slot again as well, and that's just on the back of we did a poll on Twitter which asked whether people think there'll be an increase, and 86% of people said they think there will be an increase in requests of either home working or flexible working. So I can imagine businesses are going to be getting a lot of people asking for different things. So hopefully Charlotte will be able to cover off some things in terms of process on that. So that's everything from me. Thank you all very much for joining us. If you do have any questions, just get in touch and we'll be happy to help. Take care and stay safe. Thank you.